11 of January 2016. The defendant filed an acknowledgement of service and submitted an application on the 20th of March 2016 seeking an order that the DIFC court does not have jurisdiction to try the claim, or alternatively, should it have jurisdiction to try the claim, it shall not exercise its jurisdiction and shall not hear the case. This would be our second defense.
Sure.
But it is important to clarify to the court that the claimant filed its claim under Part 8 of RDC. However, the claimant failed to comply with the Rule 8.8.5 of the RDC by not stating that the defendant is sued in the representative capacity and what that capacity is. On 3rd of April 2016, the claimant has filed 2 witness statements. The first witness statement of Ms. Susie Abdelnabi, a legal consultant at Claimant's Counsel Office, and the second witness statement of Mr. Calvin Barker, a head of legal at Claimant's company. The witness statements have been filed in response to Kassab's jurisdiction application filed on the 20th of March 2016. According to Rule 29.5 of RDC, where a witness statement does not comply with this part in relation to its form, the court may refuse to admit it as evidence and may refuse to allow the cost arising from its preparation. Kassab submits that these witness statements shall not be admitted by the court, and the court shall refuse to allow the costs arising from its preparation because the first witness statement of Ms. Abdelnabi, first, it does not comply with Part 29 of RDC, Part 32 of CPR of England and Wales, and PD 32 Evidence Supplementing CPR, Part 30 of RDC Expert Witness, nor it complies with the requirement of the rules contained in Practice Direction 1 of 2016. Practitioners' duties to the court, filing of witness statements by lawyers employed by Part 1 law firms, Paragraph 6 of Mandatory Code of Conduct for Legal Practitioners in DIFC courts, and provisions of Code of Best Legal Professional Practice, which read, the failure by a DIFC lawyer or a DIFC firm to behave in accordance with the code is likely to have consequences for that lawyer or firm in the event that such conduct becomes relevant to any case or hearing that comes before the DIFC court. Rule 1.1 reads, no person may act as a lawyer unless he is qualified as such, that is, licensed to practice law or otherwise permitted to appear as an advocate before the DIFC courts. Your Honor, the witness statement, first of all, does not have the statement of truth as required by Rules 29.32 and 29.33 of RDC, which is supported in tab 11 in our bundle. Page 91. Page 126. Page 126. Yes. 29.32, regarding the statement of truth, it states that the witness statement is the equivalent of the oral evidence which that witness would, if called, give in evidence. It must include a statement by the intended witness that he believes the facts in it are true. 29.33 reads, to verify a witness statement, the statement of truth is as follows. I believe that the facts stated in this witness statement are true. Witness statement does not comply with the Rule 29.18 as well as 29.32 and 29.33. A witness statement shall be in the witness' own words. It shall not have lengthy quotations from the documents, and it shall not engage in arguments. The evidence rule established by Your Honor, just I want to refer you to the second bundle, which is page 9, tab 11, page 91. Tab 11, page 91.
Page 91.
Yes, which is the statement of Ms. Abdel Nabi.
This authority bundle. Oh, it's that.
It is bundle A. All right, A.
Bundle A. Okay. But we are dealing with the first witness statement.
Yes,
Swiss Abdel Nabi, right?
yes, correct.
Bundle tab 13, page. Is it tab 13 or 12?
No, tab 11.
Is it? Right. 11?
Tab 11, page 91.
Yes.
At the end of the statement of truth,
Yes, yes.
Your Honor, you can see that it is written, the claimant believes that the facts stated in the witness statement are true.
Right.
And it is, of course, signed by Ms. Abdel Nabi.
Okay.
So this, of course, contradicts or it's considered a breach to the rules 29.32 and 29.33 of RTC. The evidence rule established by the evidence rule established by the Secretary of the State against Fowler and others of 12 June 2012, paragraph 47, which reads, it is in tab 22, page 309.
Same bundle?
Bundle B.
Page?
Page 309.
Paragraph 47?
It is paragraph 47. It states that the court have regularly reminded parties that the purpose of witness statement is to replace oral testimony. It is not to rehearse arguments. It is not to set out a case, and whilst it necessarily has to be drafted with collaboration of lawyers, it should not be a document created in the language of lawyers, by the lawyers, because the lawyers do not go into the witness box and defend it. It is unfair to defendants. In the witness statement of Ms. Abdel Nabi that we have referred before, Your Honor,
Yes.
on page 91, which is tab 11, bundle B, in paragraph 65, it states, for the reasons stated in my witness statement and set out above, I would respectfully submit that the application should be dismissed. At the appropriate time, I shall also submit that the DIFC court should render judgment against the defendant on the claim submitted by providing a declaration that the agreement has been validly terminated. This shows, Your Honor, that the witness statement, or Ms. Abdel Nabi, has taken a place as an advocate in this witness statement and not as a witness, giving a witness on a certain legal points. The witness is acting as both the advocate for the client and witness, which directly breaches paragraph 5.2 of the Code of Best Professional Practice, paragraph 6 of Part B, which is in tab 15, page 171.
Bundle A, tab 15, page.
Bundle B, Your Honor. Page 171.
Yes.
5.2. A lawyer shall not appear before a court in a matter where the matter is one in which he has reason to believe that he is likely to be a witness, unless his evidence is likely to be purely formal or uncontroversial, or he is not appearing as an advocate in the case. B, by reason of his relationship with the client, it will be difficult for the lawyer to maintain his professional independence. The witness violated paragraph 2.1 of PD 1 2016, which reads, which we have just read, Your Honor. However, there is no law permitting to present the legal argument of a lawyer in the case by witness statement. For witness statement is evidence, but lawyer's argument is not. It is a submission only. The defendant submits that there is unacceptable substitution of concepts, the evidence concept and submissions. Witness statement is defective because it is not available for cross-examination pursuant to Rule 29.58 of RDC. The rule established by Copling, Singer, and Fredland Limited against UBS AG 2014 before Mr. Justice Andrew Smith, paragraph 14, which is in tab 11, page 129, and bundle B, Your Honor. It is 24, tab 24, page 358.
Okay. Paragraph
14. Mr. Brazel's statement was not satisfactory, not least because it contained a great deal of argument and continuous comment on documents, a common problem with statements, despite the important guidance in 32.4.5 of the White Book. It was not only challenged in cross-examination, it was not, only unnecessarily long, but it presented UBS with an unfair dilemma about what should be challenged in cross-examination. I was not willing for him to give evidence in chief by way of confirming the original statement. Accordingly, those acting for KSF prepared an amended version of the statement which removed a good part of the more offensive contents, and I allowed it to stand as Mr. Brazel's evidence in chief so as not to disrupt the trial further. Your Honor, after we have explained the defaults in the witness statement, and we referred your court to certain evidence in our bundle. The witness or the claimant, the defendant now, tried to change the nature of the witness from a witness to an expert witness, which also was a wrongful act, because it has been submitted. As you see, Your Honor, I can refer you to the claimant in page 3, in tab 145 in the bundle.
A.
Bundle A.
Which tab again?
Tab 12.
Your Honour, if I may, I don't want to interrupt my learned friend to any great degree, but just so that it clarifies the matter, we do not rely on Miss Abdul Nabi's witness statement as an expert witness.
Take your note and
I hoped it would.
Your Honor, it has been stated in their submission.
are you still looking to the tab 11 or tab
No,
12?
I didn't find it in tab 11.
What you are looking to?
Hmm? Oh, okay.
You have 5 minutes to summarize your position.
All right. We'll get back to it, Your Honor.
For the first statement.
Okay. Just to clarify that Mr. Abnabi, she is not an expert witness, as it has been submitted by the claimant in its submission. The statement does not meet the evidence rules requirement in respect of experts, Rule 31.12 of RDC, which says expert evidence shall be restricted to that which is reasonably required to resolve the proceedings. She cannot give evidence of what the law is, except an expert in the case of foreign law. No legal consultations of the claimant's counsel, legal consultant, would be required for the court on the UAE domestic law, and the court would reject the claimant's application in the event if the claimant would ask the court's permission under Rule 31.14 and 31.15 of RDC. No permit was applied for by the claimant from the court under the Rule 31.13 and 14, which reads, no party may call an expert or put in evidence an expert's report without the court's permission. an application for permission to call an expert witness or serve an expert report should normally be made at the case management conference. Witness statement as well violates Rule 31.6 of the RDC, which reads, an expert should assist the court by providing objective opinion on matters within his expertise and should not assume the role of advocate. Witness statement is not expert opinion in its content. Rule 31.5 of RDC clarified that the expert evidence should be independent product of the expert, uninfluenced by pressures of litigations. Ms. Abdelnabi's statement is not. For those reasons, Your Honor, we request to dismiss the witness statement as an evidence in this case. And if you allow me to start with the
no, I would prefer the claimant to reply on the first witness. Then I will give you the chance to reply. Then we'll move to the second witness after.
I'm grateful, Your Honour. Your Honour, if I may, when I first read this application, I was extremely surprised. The reason being that I think, and I've asked my clerk to look this up, I believe that I've been now in 75 applications before the English courts, and in almost every single one of them, I have had a solicitor's witness statement in support of my position. If I do not have such a witness statement, I am deemed by the court normally to have underprepared for the hearing. This is entirely normal practice, both in England, and I only raise England because my learned friend has raised English cases, but also before this court. However, to respond to the substance of the application, can I take you to why this witness statement was produced? And the answer to that is in the main bundle, I think, which has been referred to as Bundle A, and tab 3.
Yes.
This is the jurisdiction application, and at section 3, titled Details, if you can see that, Your Honour. This is page 6, and it says there, how do you? This is the defendant's application. It says, how do you wish to have your application dealt with? In the box it says, without a hearing. And so, Your Honour, what the position that puts my client in is that it needed to put in some source of material in writing so that the court could deal with this application. It chose, I submit, a very normal way to submit that material in the form of witness statements. One, the factual witness statement of Mr. Barker, the other being the quite normal solicitor's witness statement of Ms. Abdelnabi. Now, it might be right to say that that has a little more legal content than one might expect. I accept that. There are exhibits which include, for instance, extracts of the commercial code, but that really was the only material that the claimant was likely to be able to rely upon in the jurisdiction application if this was all going to be dealt with on the papers. And of course that is what the defendant was inviting the court to do. It was inviting the court to deal with this application without a hearing and therefore a paper-only application. It is also said, Your Honour, that this witness statement is in some way abnormal or a breach because its content is legal. And, Your Honour, in my submission, that really is not the appropriate position. And I'm going to take you, if I may, to RDC 29, which appears behind tab 11 of what I think is called Bundle B for you. But Your Honour, I see you've got the guide in front of you. I'm not going to take you away from the guide.
RDC
29 and 29.131 in the first instance. Your Honour, these provisions, 29.131 to 29.135, envisage that there will be witness statements in relation to questions of non-DIFC law. And, Your Honour, as regards this application, what Ms Abdelnabi was doing was setting out the position under UAE onshore law, and she did so in exactly the way that 29.131 to 29.135 envisages. And so in my submission, Your Honour, in fact, Part 29 expressly envisages that questions of UAE onshore law can be dealt with in factual witness statements. There's also the question, Your Honour, of whether or not Ms Abdelnabi was approaching her task as that of an advocate. Your Honour, you see who's standing and you see who's sitting in this hearing. I am standing as the advocate because I am Part 2 registered, among other reasons. Ms Abdelnabi is not acting as an advocate. She was simply putting in a statement as one would expect. Your Honour, I don't wish to occupy the court's time any further on this issue. If there are any specific queries that you have for me, I'm of course willing to respond to them. But in my submission, this is actually extremely clear. There is no question of any misconduct here. It is true, of course it is true, that the statement of truth is not in exactly the form envisaged. I have to make that concession. There is a very tiny error, which is that instead of the words I, it says the claimant. Your Honour, if that is fatal to this witness statement, I'd submit that would be surprising. But if that is a fundamental defect in this witness statement, which means that you cannot refer to it at all, then in my submission, I can still argue the jurisdiction application without it, if you want me to. But in my submission, that shouldn't be necessary, and it isn't necessary.
Just one question before we move to the defendant to reply to your position.
Yes.
What's your view in terms of the practice direction number 1, 2016, regarding the filing of witness statements by lawyers employed by Part 1 law firms? The fact we are dealing with here, which is a little bit different than the normal practice where solicitor always file witness statements, is that this is the witness is employed by the law firm who is proceeding in this case.
Quite.
And giving an opinion a little bit, further than just a normal opinion in terms of the legal opinion and.
Well, Your Honour, the reason for that, as I've tried to explain, is
I
because
understand why the initial claim to be dealt with without hearing, and this is your position.
Exactly.
I understand that.
And so, in fact, there is little choice in the matter as to how Ms Abdelnabi could present the material that she wants to put before the court. The reason being that the claimant had to make clear to the court, if nothing else, for your ease of reference, what the claimant's position really was. And in my submission, she did that in a perfectly proper way in a witness statement. Now, the only reason why we are where we are is because the defendant made the application stating that it would be without a hearing. Of course, everything, had it not been stated in Part 3 of the application notice that this was to be dealt with without a hearing, then everything would have proceeded as normal, with relevant provisions of UAE law referred to in my skeleton argument. As it is, the only result of all of that material having been put into Ms Abdelnabi's witness statements is that the defendant has more advance notice of the claimant's arguments. Because, of course, the witness statement was served well in advance of my skeleton argument.
Well, thank you very much.
I'm grateful.
If you want to reply to that
Yes.
before we move to the second witness statement.
Your Honor, our request to try the claim without a hearing does not justify to provide an evidence such this evidence. The claimant could have provided the court with an independent solicitor witness statement other than Ms. Abdelnabi, which is the advocate or represent the claimant itself. And just we would like to ask the court to record that the claimant has acknowledged that there is a breach in this witness statement to RTC rules, and it consists of legal arguments due to what they have said, because it is, as they said, it is a proper practice or familiar practice, which I disagree on that.
All right. Shall we move to the second witness statement?
Yes. Your Honor, the second witness statement of Mr. Calvin Barker, this statement does not comply with Part 29 of RDC and Part 32 of CPR of England and Wales and Practice Direction 32, Evidence Supplementing CPR. The witness statement does not have the statement of truth as required by Rules 29.32 and 29.33 of RDC, which we have explained previously, and Rule 20.2 of the PD 32 Evidence Supplementing CPR, which rules say a witness statement is equivalent of the oral evidence, which that statement would, if called, give in evidence. It must include a statement by the intended witness that he believes the facts in it are true. To verify a witness statement, the statement of truth is as follows: I believe that the facts stated in this witness statement are true. Instead, the witness says the claimant believes the facts stated in the witness statement are true. Witness statement does not comply as well with Rule 29.17 and 29.18 of the RDC. It is not merely statement of fact in witness' own words. Witness advocates on the claimant's behalf and submits his own request before the court, which is not the witness' mission. Therefore, the witness would not be allowed to repeat the same orally what he said in paragraph 4 and 18 of his statement, should he be called for the evidence rule established. Your Honor, just I want to refer you to the bundle A, tab 13, page 141, paragraph 18.
Yes.
For the reasons stated in my witness statement and the witness statement of Susie Abdelnabi and set out above, I would respectfully request that the application be dismissed. This is not the mission of a witness. In addition to that, it seems that the second witness statement has relied on the witness of Ms. Abdelnabi, as stated here, which is also shows that it is not, there is no independency in drafting those witness statements. In addition to that, in page 139, Your Honor, paragraph 4, the witness states, as set out in this witness statement and the witness statement of Susie Abdelnabi, dated 3rd of April 2016, the claimant submits that the defendant's application should be dismissed by the court and the DIFC court should confirm that they do have jurisdiction. So the witness here is taking the task of the claimant himself and not an independent witness statement. The witness is not an eyewitness in respect of agreement negotiation starting. He joined the company late, as clarified in his witness statement. This witness is merely commenting on the documents preceding his employment in the company and makes expression of own impressions and on behalf of his colleagues. Witness makes quotations from the documents and gives conclusions thereon. The witness, Your Honor, was not there, was not employed with the claimant during the drafting of the agreement and signing the agreement. So he's just commenting on information or that he has, as he expressed, got from his colleagues. This is contrary to the role of the witness, the role established by Justice Weatherpoon against Harris before Chancellor of the High Court, paragraph 33, which states the vast majority of Mr. Goldberger's witness statement contains a recitation of facts based on the documents, commentary on those documents, particularly on aspects of commercial property market. In all those respects, Mr. Goldberg's witness statement is abused. The abusive parts should be struck out. The witness statement, as the witness has mentioned in his witness statement regarding the interim agreement made on April 2013, it is irrelevant to the case. For the matter in the case, for the interim agreement has replaced the agreement made in July 2013. So the interim agreement is irrelevant to the case and it should be dismissed. For those reasons, Your Honor, the court is invited to reject the admission of the witness statement of Mr. Abdel Nabi and Mr. Baker in full and to refuse to allow the costs arising from their preparation.
Thank you.
Your Honour, this is a perfectly normal factual witness statement. And in reality, all other submissions that I make in relation to this application are going to be predicated on that basic proposition, which is that this is a perfectly normal factual witness statement. Although it is said that Mr. Barker is in some way spoken without independence, in some way has not used his own words, I'm just going to relay to you, I'm just going to read through certain passages of this witness statement and demonstrate that in fact he does use his own words and is always purporting to use his own words. Paragraph 1, I am head of legal of the claimant in these proceedings. Paragraph 2, I provide instructions to Clyde & Co. LLP. And Your Honour, just pausing there, it is slightly odd that it is said that Mr. Barker is not independent because he has read the witness statement of Ms. Abdel Nabi, given that Ms. Abdel Nabi is someone that he instructs. But we'll put that one to a side. I am authorised by the claimant to make this witness statement on its behalf. Paragraph 5, there is now shown to me and attached a paginated exhibit bundle marked KB1 containing the true copy documents on which I rely and to which I shall refer in this witness statement. I make this witness statement from facts and matters within my own knowledge and on the basis of documents and information provided to me by others. He then sets out his own experience. He says, I was involved in the negotiations in the period before the agreement between the claimant and the defendant. I don't quite understand why my learned friend says that somehow he is reciting the experience of others. The only extent to which that is true is at paragraph 11. It's expressly stated. From the claimant's side, the negotiations were initially led by Sophie Taylor, the legal director, who was my predecessor, and Tony Donovan, who was previously chief operations officer at Sky News Arabia. I was involved later, after I joined Sky News Arabia in mid-June 2013. And so, Your Honour, everything from paragraph 11 on